In 1986, the Supreme Court ruled that an electric company has the same constitutional right as a human being, the right to simply refuse to speak. Not a CEO, not a shareholder, the corporation itself, as a legal entity, walked away with an inner conscience the Constitution is supposed to protect. And the case that built this right had nothing to do with elections or campaign money. It started with a few inches of empty space inside a monthly gas bill, and 3 million customers who had no idea their mail had become a battlefield. The company was Pacific Gas and Electric, PG&E, California's largest power utility, and at the time, a state-sanctioned monopoly, which meant by law it was the only option millions of Californians had for electricity. PG&E was in trouble. It was finishing the Diablo Canyon nuclear power plant, and the project had ballooned into a billion-dollar mess after engineers discovered the blueprints for 2 reactor units had been swapped mirror image, forcing an expensive retrofit. To recover those costs, PG&E asked regulators for permission to raise rates on its 3 million ratepayers, roughly the population of Chicago, all being asked to help pay for somebody else's engineering mistake. A state-sanctioned monopoly, asking the only customers it had, who had nowhere else to take their business, to cover its own blueprint error. If Ione had a mailing address, this would be it. A consumer group called TURN, short for Toward Utility Rate Normalization, pushed back, and TURN had noticed something PG&E never planned for. Every month, PG&E mailed its bill inside an envelope, and every month it tucked in a company newsletter called Progress, part energy-saving tips, part editorial defending its rate hikes at its nuclear plant. PG&E had been doing this for over 60 years, long enough that nobody at the company had ever had to ask permission. Here is the detail that decided this entire case. The envelope had a postage weight limit. Once you accounted for the bill itself, the legally required notices, and that newsletter, there was still a little blank space left over inside the envelope. Paid for, sealed, and mailed out, but unused. California's utility regulator, the CPUC, looked at that blank space and ruled it belonged to the ratepayers, not the company, because the ratepayers were the ones footing the postage. So the CPUC ordered PG&E to hand that space over to TURN 4 times a year for 2 years, so TURN could share its own opposing view on the rate hikes and ask for donations. This wasn't happening in a vacuum. Wisconsin had already passed a law back in 1979, letting a consumer board do exactly this: use utility billing envelopes to organize ratepayers and raise money. Illinois copied the idea in 1983. California's own regulator had gone further still, ordering a separate utility, San Diego Gas and Electric, to carry similar messages from a different consumer group. Utility companies across the country watched this model spread state by state, and they saw something closer to an existential threat: the permanent, unchecked control they had always held over their own customers' mail was starting to slip. PG&E said no. Not out loud. PG&E took it straight to court. The company argued that being forced to carry a stranger's opinion inside its own envelope violated something specific: its negative speech right, meaning the constitutional right not to express, publish, or distribute a message it disagreed with. That right already existed for people. The Supreme Court had ruled years earlier that the government cannot force an individual to display a slogan on a license plate if that person finds it morally objectionable. PG&E's lawyers wanted that exact same shield, just stretched to cover a corporation. And PG&E wasn't fighting alone. Tobacco companies and large financial institutions were quietly funding parallel constitutional battles of their own. Each one betted that a win for PG&E would help knock down warning label laws and campaign spending limits everywhere else. None of these industries cared much about envelopes. They cared about precedent. To win, PG&E needed two legal ideas to merge into one. The first is corporate personhood, the legal fiction that treats a company as an artificial person, letting it sign contracts, own property, and sue or be sued in its own name. That idea wasn't new. Back in 1886, the Supreme Court had already used it to give corporations equal protection over their physical property. The second idea PG&E needed is the commercial speech doctrine, the rulebook for business talk, covering speech that does nothing more than sell a product. That kind of speech only earned First Amendment protection in the mid-1970s, and even then, on a short leash. The government can still ban a false ad outright or force a true one to carry a warning label. PG&E's argument skipped past that weaker shield completely. This was never a fight about selling electricity. This was a monopoly utility, claiming a human-style conscience, an inner editorial freedom the government cannot force it to violate. Building on a 1978 case called Bellotti, where the court had let corporations spend money on ballot campaigns, but only by focusing on the public's right to hear more viewpoints, not on the company's own right to express itself. At oral argument, one justice pressed PG&E's attorney, Robert Harris, on whether any prior case had actually given a corporation this kind of personal, human-style right. Harris pointed straight back to Bellotti. The justice pushed back immediately. That case was about a corporation spending its own money, not about a corporation being forced into silence or forced to speak against its will. Harris admitted it. No case had ever ruled that way before. He wasn't citing precedent. He was asking the court to write some live, on the record, in front of 9 justices who had never been asked that question. And in a fractured 5-3 decision, the court said yes. Justice Lewis Powell's plurality opinion ruled that the CPUC's order was unconstitutional because it handed envelope access only to PG&E's opponents, forcing the company to either stay silent to avoid controversy or respond to hostile messaging it never chose to engage with in the first place. Powell wrote that the choice to speak includes within it the choice of what not to say, and for the first time extended that exact choice to a corporation. Justice William Rehnquist dissented furiously. Giving a company an intellect or a mind for the purposes of conscience, he wrote, confuses metaphor with reality. A corporation cannot feel coerced. A corporation cannot suffer a violated conscience. It is a legal tool for raising capital, not a person with a soul. Justice Stevens dissented on narrower ground entirely. The order never silenced PG&E, then never forced it to repeat anyone else's words out loud. It simply used a heavily regulated piece of mail, not a private printing press, to let ratepayers hear a second opinion before they paid their bill. The ruling stood. PG&E won, 5 votes to 3. The envelope order was struck down. Turn never got its space. Not once. Not in 4 scheduled mailings, not over the full 2 years the CPUC had ordered. But the real verdict was never about an envelope. It was about an idea. The court had just handed a state-sanctioned monopoly the same inner conscience the Constitution was built to protect in human beings. One sentence did it. The choice to speak includes the choice of what not to say. 11 words. They didn't stay in California. They didn't stay with utilities. Lawyers for tobacco companies took the sentence. Banks took it. Trade groups took it. 24 years passed. Then the Supreme Court reached directly back into this same reasoning to strike down limits on corporate election spending. In Citizens United versus the FEC, the Federal Election Commission, the agency that polices how money moves through American campaigns. That 2010 ruling passed by a 5-4 vote, one vote tighter than the one that started it all, back in a billing envelope in California. Here's why this case still reaches into your life today. Every time a corporation successfully fights off a mandatory warning label, a safety disclosure, or a disclaimer by claiming the First Amendment right not to say something, it is standing on legal ground PG&E poured back in 1986. The same reasoning helped dismantle the consumer board funding model that Wisconsin and Illinois had built, leaving local consumer advocates with far fewer resources to challenge utility monopolies, while those same utilities kept passing their own lobbying and litigation bills straight onto customers' monthly statements. And in the decades since, that same inner conscience the court protected has helped to justify unlimited corporate election spending through super PACs, political committees that can raise and spend unlimited money on elections, as long as they don't coordinate directly with the candidate's own campaign, funded out of corporate treasuries that no individual customer, and often no individual shareholder, ever voted to open up. A Supreme Court spent 2 years deciding whether a company has a conscience worth protecting. The shareholders who actually owned that company never had to show up for the vote. Neither did you, and you've almost certainly paid into one of these treasuries through a utility bill, a bank fee, or a subscription, without ever being asked. So here's the debate worth having in the comments. Should a corporation ever get to claim the same inner freedom the Constitution built to protect individual human conscience? Or should that protection end the moment a business files its corporate charter? If you want more of the cases nobody teaches you in school that quietly rewired how power actually works, subscribe to Legal Curiosities. Next week, the trademark lawsuit where a company's own court filings accidentally proved its biggest product name had become an ordinary word in the dictionary and cost it the rights to its own brand.